stand here on the premise that the integration of Jammu and Kashmir into India is unquestionable, was unquestionable, and always remain unquestionable. Therefore, there was no reason to take away this right. It's in that context, Mullah, that I'm mentioning this. Now, Mullah, I'll go to the list of dates. You will note here, Mullah, Jammu and Kashmir is not part of this. And the states would retain jurisdiction over all other subjects not ceded to the Union. First, Mullah, that your Lordships will be analyzing why history was tossed out on the 6th of August 2019. Whether the procedure adopted by Parliament was consistent with what democracy stands for, whether the will of the people of Jammu and Kashmir could be silenced in this fashion, whether they will be denied a representative form of government through a diktat of the Union inconsistent with our Constitution. It is also historic because it has taken 5 years for your Lordships, Mullahs, to start hearing this case. And for 5 years, Mullahs, there has been no representative government in the state of Jammu and Kashmir. It is also historic because you will have to interpret Article 356 of the Constitution of India, an article which seeks to restore democracy. And how do that process? Through an article which sought to restore democracy, you have decimated democracy. Can that be done under Article 356? That the state of Jammu and Kashmir historically represented a very unique relationship, unlike princely states and the states of India which were integrated into the Union. Whether that historic relationship between sovereign authorities could have been jettisoned in this fashion by seeking to amend the Constitution and seeking to efface Article 370. Whether, Mullahs, a governor of a state could have, on the 20th of June 2018, decided that I will keep the assembly under suspended animation, which is the power of the governor alone under the J&K Constitution, without even trying to find out whether they can form a government or not. Because on the 19th of June, a particular party withdrew support, and on the 20th of June, the governor passed this order. Whether on the 21st of November 2018, Mullahs, a dissolution of the assembly could have taken place before the imposition of Article 356. The governor on the 21st of June dissolved the assembly without reference to 356. And thereafter, Article 356 was used. And the manner that it was used will be, Mullahs, I will address your Lordships on those issues. These are issues that will arise for your Lordships' consideration, never raised, never decided by this court. So in that sense, too, it is historic. So, Mullahs, I will proceed because there is a historical context to the state of Jammu and Kashmir, Mullahs. So I will have to take your Lordships through that history. And if your Lordships will permit me, Mullah, I'll start with a list of dates. Before this, may I, Mullah, want to make one statement clear, Mullahs, that we stand here on the premise that the integration of Jammu and Kashmir into India is unquestionable, was unquestionable, and always remain unquestionable. That was a given. And despite that, Mullahs, the whole structure was overnight, Mullahs, changed through a process which I will demonstrate was unconstitutional. When your Lordships will be dealing with this matter, there will be 4 legislations in a sense that you'll be dealing with. One is the Constitution of India. The second is the Constitution of India as applicable in the state of Jammu and Kashmir. Third is the Constitution of Jammu and Kashmir. And fourth is Article 370. And the interaction between these three constitutions in the context of Article 370 is something that your lordships will have to look at as we move forward. But please keep that in mind. The reason why I say Constitution of India is applicable to the state of Jammu and Kashmir, that over time, there were several orders issued, constitutional orders from time to time, which were incorporated in the Constitution of India as applicable to Jammu and Kashmir. The result was that most of the powers, most of the responsibilities and powers were actually in tandem with the Constitution of India. There was, in fact, really no difference other than Article 370 itself. All the laws were applicable, except that those laws were replicated in the constitutional orders of the government of India. Therefore, there was no reason to take away this right. It's in that context, Mullah, that I'm mentioning this. Now, Mullah, I'll go to the list of dates. On the 9th of March, 1846, the Treaty of Lahore was executed between Maharaja of Lahore and the British government, resulting in the transfer of certain territories to the East India Company, in particular under Article 4 of the treaty. The Maharaja cedes to the Honorable Company all his forts, territories, rights and interests in the hill countries which are situated between the river Beas and Indus, including provinces of Kashmir and Hazara. Earlier, Jammu's Maharaja Gulab Singh's General Zorawar Singh had invaded Ladakh in 1834. Ladakh came under Dogra rule and was incorporated into the state of Jammu and Kashmir in 1846. During the Sino-Sikh War, the Qing Empire invaded Ladakh, but the Sino-Tibetan army was defeated. Ladakh was claimed as a part of Tibet by Phuntstok Wangyal, a Tibetan communist leader. In 1947, partition left Ladakh a part of the Indian state of Jammu and Kashmir to be administered from Srinagar. On the 16th of March, 1846, following the Treaty of Lahore, the British government executed the Treaty of Amritsar on March 16, 1846. Under the treaty, the hilly mountainous country with its dependencies situated in the east of River Indus and west of River Ravi, including Chamba and excluding Lahore was transferred by the British government to Maharaja Gulab Singh of Jammu. The reason was simple, Maharaj. There was a violation of the Treaty of Lahore, and therefore compensation had to be paid, Maharaj, to the British government. He was not able to pay that compensation. In lieu of that compensation, these territories were ceded. That's what happened. On the 30th of June, 1857, Gulab Singh died and was succeeded by his son, Ranbir Singh. Following the passage of the Government of India Act 1858, territories formerly in possession under control of the East India Company were vested in the British monarch in whose name India was to be governed. 1885, Maharaja Ranbir Singh died and was succeeded by Maharaja Pratap Singh. In 1889, 30th of August, the Interpretation Act of 1889 was passed by the UK Parliament. Section 18.4 of the Act defined the expression British India. All territories and places within Her Majesty's dominion, which are for the time being governed by Her Majesty through the Governor-General of India. In addition, the term India was defined under Section 18.5 as British India, together with any territories of any native prince or chief under the suzerainty of Her Majesty exercised to the Governor-General of India. You will note here, Mother, Jammu and Kashmir is not part of this. In 1925, Maharaja Pratap Singh was succeeded by Maharaja Hari Singh, the last ruler of the princely state of Jammu and Kashmir. And on the 20th of April 1927, the expression state subject was defined in the state subject definition notification dated April 20, 1927, which was issued by Maharaja Hari Singh. This notification classified state subjects into 4 classes and subsequently became the basis for the definition of permanent residents of Jammu and Kashmir under the Constitution of Jammu and Kashmir and Article 35A of the Constitution of India. Your Lordships need not go into it because we are not really dealing with that issue, but I'm just mentioning it. On the 22nd of April, 1934, Maharaja Hari Singh enacted Regulation 1 of Samvat 1991 on April 22, 1934. Wherever there is Samvat, if you take away 57 years, that gives you the year. The regulation established a legislative assembly for the state of Jammu and Kashmir called the Praja Sabha. While certain legislative functions were delegated to the Praja Sabha, the ruler, Maharaja Hari Singh, retained supremacy over all legislative, executive, and judicial matters. On the 2nd of August 1935, the Government of India Act 1935 was passed by the UK Parliament. The Act established India as a federation comprising governors' provinces, chief commissioners' provinces, the Indian states which had or would accede to the Federation of India. Under Section 6 of the said Act, the ruler of Indian princely states was empowered to execute an instrument of accession, declaring that he accedes to the Federation of India, subject to the terms of such instrument. Under Section 2, an instrument of accession was to specify matters with respect to which the federal legislature would have competence to legislate for a particular state and the limitations, if any, on the federal legislature's powers to make laws or exercise executive authority over such state. Notably, as the state of Jammu and Kashmir was not a part of British India, provisions of the Government of India Act 1935 did not apply to it unless an instrument of accession was executed by its ruler in accordance with Section 6. On the 7th of September 1939, the Jammu and Kashmir Constitution Act 1939 was promulgated. While Maharaja Hari Singh retained sovereignty and supremacy over all legislative, executive, and judicial functions, the Act provided the Praja Sabha to make laws for the entire state of Jammu and Kashmir or any part thereof, subject to certain conditions. Further, the said Act vested executive functions with council consisting of a Prime Minister and other ministers appointed by the ruler. The Act also provided for the High Court, which had been established by the ruler in 1928, to be a court of record with jurisdiction to adjudicate upon inter alia civil suits, civil, criminal, and revenue appeals. On the 16th of May 1946, the Cabinet Mission issued a statement regarding its report. Under paragraph 15(1) and 4 of that statement, the Cabinet Mission plan envisaged a Union of India where the Union would have responsibility over defense, foreign affairs, and communications, and the states would retain jurisdiction over all other subjects not ceded to the Union.